Welcome to Lawyers Who Care, the video show podcast that highlights attorneys who go above and beyond for their clients. And on each episode, we will meet a new lawyer and they will share stories of when they went beyond legal counsel for the benefit of their client. My name is Andrew Samalin. I'm the principal of Samalin Wealth, a nationally recognized wealth management firm for lawyers, their firms, and their clients. So let's applaud Lawyers Who Care and learn from them. Today, my guest is Justin Kelsey. He's a partner at Skylark Law and Mediation in Boston. And Justin concentrates his law practice on collaborative divorce, mediation, and representation in Massachusetts. Welcome, Justin.
Thanks, Andrew. Thanks for having me on.
So, Justin, tell us about what brought you to the law.
So I actually wanted to work in government. I was working in the Department of Public Health when I was in law school. And I got a little bit burnt out on how slow things move. So I took the first law firm job I got offered, and it was doing divorce litigation. I had not planned to do family law, didn't know that's where I was going to end up. And I worked for that firm for about 4 years and figured out I had a really good knack for settling cases that were headed to trial, for finding ways to settle difficult cases. And so I started to look into taking the mediation training. I opened my own firm. I took the collaborative law training, and I realized those skills that now that I teach in those trainings were things I was sort of doing naturally, finding the interests from the other side, figuring out how everybody could win, especially in family cases where staying out of court and finding collaborative solutions can help both people and their kids. And so I kind of found my place where I belonged when I figured out trial work wasn't it for me. But I, in that sort of circuitous way, ended up in the mediation and collaborative community.
So you're using a couple words that maybe some of your viewers it might be new to them, where you've got this concept of litigation, this concept of collaborative law, and then mediation. Can you share what some of the differences might be and who they might be appropriate for?
Sure. Yeah. So when I started out, I was doing primarily litigation. I was working for a partner who did a lot of trial work, and that was his specialty. And so I second chaired a few trials, and I started doing my own trials. And that's what essentially litigation is using the court system to try and resolve a case. Most cases don't go to trial. Most cases still settle. But you're using, formal discovery, motion practice to get information, and a more formal negotiation space. Now what I do is sort of completely different than that. It's completely outside of court work. And it includes a few different things. Mediation, whether I'm the mediator, which is a neutral role where I'm working with both sides to try and help them resolve their case, and I'm not working as an attorney. I'm not representing either side. I still have the knowledge of being an attorney, but I'm sharing information. I'm not giving advice, and I'm helping facilitate conversations. Or I still do represent clients as an attorney. Sometimes they're in a mediation, so someone else is the mediator, and I'm helping my client advocate for themselves, but in a space where everyone has the same goal, to reach an agreement without a judge making a decision. And then collaborative work is sort of a design process where that's the intent from the start, is they're going to be a neutral in the room, usually a coach, sometimes a mediator coach, and attorneys for each side, but they're collaboratively trained attorneys, and they're focused on settlement. And so while you still have an advocate in the room, while you have a neutral leading the conversation, there are some rules that everyone puts in place to say, we're doing this in a way with the intent of doing it outside of court. So we have, instead of formal discovery, which the court process has these rules about what you can get and what you can't get, in a collaborative case, it's all voluntary. If you need certain information to make decisions, we all exchange that information, and it's much less formal. It's also usually more efficient and cheaper in that way. And everybody just agrees up front that one of the tenets of that type of a process is transparency. So you're all going to have the same information to make decisions on. It's not, you have to figure out what to ask for and ask the right questions. We're just going to share the relevant information. And that usually speeds us to a conversation about resolution faster. It doesn't mean those conversations are necessarily easier. People still disagree. And sometimes collaborative cases can be really complicated. And so can mediations. But everyone has a different goal. The goal is that we're only going to leave that room or those meetings with a solution that everybody signs on to, rather than have a judge decide or always have that threat in the background, even when you're settling. I like that approach because I do mostly family law, and the decisions that are getting made affect every aspect of people's lives. It affects their finances, their parenting time, their relationships. And so empowering them to make those decisions, it's really important. Personally, I also think most of my clients end up happier than when I used to do litigation. Even when they won, they didn't feel like they made the decision. You give up a certain amount of power to the court.
And you had mentioned you had an interesting client story you wanted to share.
I do. So I was thinking about this, and I always sort of focused on, because I did litigation first, some of my cases I end up thinking about how much different this would have been if it had gone that route. And there's one case when I was relatively new to collaborative. I had been mediating for a while, and still negotiating divorces in a way that what we sometimes call small C collaborative, trying to agree we're doing it outside of court, but not necessarily agreeing that it has to be outside of court. That if one of the attorneys or one of the clients decides it needs to move into the court process, it still can. Whereas big C collaborative, we're usually saying upfront there's an agreement where it's, if they decide to go to court, they have to hire new attorneys. I was doing what we call a lot of the small C collaborative, where most of my cases were staying out of court, but we'd go to court if it had to. And I took the collaborative training and started getting those cases. And only about a year into doing that, I got referred a case from another collaborative attorney who I knew, who's also a mediator. That's also one of the unique things about doing collaborative work. I get cases from opposing counsel all the time, because we refer to people we want to have collaborative cases with. In litigation, that doesn't happen very much. When I was doing litigation, I wouldn't get referrals from other litigators. I'd get them from past clients and referral network, but not other attorneys that I could be opposite of. But in collaborative, that happens all the time. And in this case, that's what happened. The other attorney, her client wanted to do this as a collaborative case. She recommended some people. I was one of the people on the list, and my client said, I want to do this as collaborative as well, hired me. And within a month, the case got really difficult. There was a primary source of income was a business that they had run together. So that's really complicated financially. And my client was leaving the business and losing your marriage and your business and some of your identity. What does it mean to be a parent when you're getting divorced? It was a lot for her to go through. And she stepped away at one point and said, I don't know if I can do this. Why don't you just take custody of the kids and you just take everything and I need a break. And she went and stayed with relatives for a couple weeks. And the other attorney showed an immense amount of compassion to check in and say, is your client okay? Are we going to put this on pause? What are we going to do in the meantime? And in a litigation case, that would have been an opportunity to get a court order that says your client has custody, get the financial set up as best you can for your client while the other side is, showing weakness. And that the other attorney did the opposite there and said, this is obviously something's going on with your client. Let's make sure she's okay. She's the mom of these children. And she got help. A month later, we were sort of back to what are we going to do with this? And that case ended up taking, I think, 3 years to settle, where they would kind of go off and be in stasis for a little while and come back when they could handle it. We're having, a lot of emotions around how to deal with it, the divorce and the breakup of the business and everything. But ultimately, they ended up with a 50-50 parenting plan. And I heard from doing an estate plan years later for my client how they were doing, and the kids were doing well. They really had even managed to stay friends, and the parents. And I see that case as one that could have been in court forever if it was in a situation where the other side ran into court and got a custody order saying, the other parent saying they can't have the kids, they can't deal with this right now. Give me full custody, and then forever that would be trying to undo that or step back from it. So it's one of those weird cases where some people might argue that other attorney didn't advocate as strongly as she could have. I see it as she advocated for a strong family unit long term, and the impact on that family compared to what I'd seen when I did some litigation work is night and day. And that sort of drove me to say, I'm going to do more of this work and sort of shrink the amount of litigation work I'm doing. I want to work with attorneys like that who you can be compassionate on both sides for the people that you're working with, whether it's your client or the what we call the opposing party as lawyers, but really it's just the other parent in the case. And I've been doing that practice now almost primarily for the last 12 or 13 years. Gave up litigation work, and it's more rewarding. And the cases that stick out to me are the ones where you think, oh, how much worse would this benefit if it was in the court process?
For sure. By the way, my guest today is Justin Kelsey. He is a partner at Skylark Law and Mediation. Justin, can you provide your or our audience with your contact information, please?
Yep. So my website is skylarklaw.com, and I can be reached at jkelsey, jkelsey at skylarklaw.com. And
you're on most social media?
Yep. So I think, we're on, there's a Skylark Law, I guess X now instead of Twitter, whatever it is. We're on Facebook and LinkedIn. I probably use LinkedIn and TikTok the most. I'm at that mediator on TikTok.
Got it. Wonderful. This has been the Lawyers Who Care video show podcast, by the way, that highlights attorneys who go above and beyond for their clients. And I think this has been a superb example of just that. If you're an attorney or no one who goes above and beyond, feel free to reach out to us, 914-666-6600. And Justin, thank you so much for joining us today.
Thanks for having me on, Andrew.